Hello and welcome. Today, we're going to be talking about how you can have better legal outcomes. More importantly, how you can have a better relationship with your attorney. And it doesn't matter what attorney you have, right? Like this is something that I see clients struggle with, whether it be my clients or whether it be other attorneys that struggle with this with their clients. So this is coming from a broad range of people that are looking to make sure that you're getting the best representation possible. But it's true in everything. It takes two. There are two parties to this, two or more parties to this. There's you and your attorney. And if I can help you to work better with your attorney, then you're going to have a better, more successful outcome because you will understand more about it. So we're going to walk through the steps, the things that you need to consider, and the way that you can appreciate and approach the attorney-client relationship to make sure that you're getting the representation you want and the representation that you need. If you are new here, my name is Taylor Darcy from Think Legal, where I help you, and I'm going to fix this really quickly because I just realized I'm like way above this, where I help businesses and people with their legal needs. I go live Monday through Friday, except for when I have other things that happen. I apologize. I would love to go live more frequently. But if you don't catch me live, please stop in, leave comments. I respond to comments. I try to help as much as I can. So please make sure that you're doing it. So we're going to dive deep into the things that can help improve your relationship with your attorney. Feel free to pass this along if you have friends or relatives that are struggling with their relationship with their attorney, because over the next several, so total of 3 episodes, I'm going to be outlining ways that you can have a better relationship as well as expectations of the attorney-client relationship or your legal outcome. So let's get started, shall we? So first is lawyers are not miracle workers. We will do our darndest to solve your problem. But unfortunately, not every problem can be solved the way that you want. It's simply not possible. Because, and here's where it comes down to, you need to have realistic expectations based upon your case. Understand that legal outcomes depend on the facts, available evidence, and the law. Lawyers cannot change these parameters. They can only navigate them. That's one thing that people get, they misunderstand when it comes to, like, when you're looking at media or you're looking at the way that lawyers are portrayed on TV, that we skirt the law and we try to bend and break the law to get the best outcome possible, even if it's against the law. That's not real. That's not what happens. We work within the law to get you the best outcome, not outside the law. Those are terrible media portrayals. So don't have your expectations based upon what you see on Suits or any other type of legal drama, because 90% of that stuff is just that. Hollywood hype to made look interesting, because realistically speaking, and truth is, most of what we do is boring. That most of it, not all of it. There's some pretty exciting stuff, but solving your problem comes down to navigating what we're working with, not trying to make the ocean, make the law. We are typically just navigators. Okay. Next thing is you're going to want to have set clear goals. When you're talking with your attorney, talk to them about what you're hoping for. What is a good outcome for you? If they don't know, they can't address it, okay? And sometimes some attorneys are so busy they forget to discuss it with you. And I'm sorry that happens, but it's true. So setting clear goals. If you're discussing with your attorney, yes, a total dismissal if you're dealing with criminal charges would be great. That's not necessarily realistic depending on the facts, the circumstances, okay? So be involved with your defense, or if you're a plaintiff, if you're trying to sue someone, then be involved with that. Communicate. What is a win for you? Is it an apology, maybe, right? Is it What type of dollar damages are we talking about? What is a win? When you do that, you're going to have a more successful outcome, because if the attorney sees that you're going off on the, let's just say the perfect outcome as opposed to a good outcome, then their job should be to rein you in and help you to see that a good outcome is sometimes better than a perfect outcome that takes forever for it to happen. We'll talk about that in a second. So before you meet with your lawyer, here's your action tip. Write down your objectives and any questions about what the attorney's feelings and thoughts are about solving those objectives. If you don't communicate it to them and they don't ask, then it's one of those areas that causes conflict and concern, okay? So when you're communicating with them, it sets a realistic stage for the journey. If you're not communicating with them, I tell my clients, I'm not a mind reader. I don't know what's going on in your mind. So if you don't tell me, then if you don't tell me what's going on or what your concerns are, I have no way of meeting them. I have no way of addressing them if you do, okay? So be communicative in your process. Next. The value of patience cannot be overstated when you're dealing with legal matters. Courts, the legal system, government entities do not move fast. In some instances, you can, some government ways you can pay extra to get things moving faster, but that's very limited scope. That's very limited circumstances. Do not think that applies. Most of the time, you are stuck with whatever the time frame is that that particular entity is working with, okay? And I'll give you a couple of for instances. So if you're filing articles of incorporation or organization with the Secretary of State in your area, they have, you can pay for expedited processing and you can pay for same-day processing, and it all gets more expensive as you go, the faster you want it. So it depends on what you're willing to pay at that point. Most people don't need that, okay? So that's one example. The other one is a court. Courts don't move fast. Like you file a summons and a complaint or a lawsuit starts, and it's a minimum of 30 days after someone's served that they are required to respond to the summons and complaint. So even if you go to court tomorrow, right, you're looking at a minimum of 30 days for something to happen, unless there's a settlement potentially involved in there. Just depends. So you want to keep these realistic expectations involving it. So your timeline, okay? Most court cases can take anywhere between a year to 2, all the way up to 5 in California. So it just depends. There's so many factors, so many variables. You don't, unlike the TV shows where they go to court one day and they solve the case the next week, that doesn't happen. It just does not happen. So if you're looking at like fast, expedited outcomes, you're gonna be sorely disappointed. It's just not how the court system works at all. So when you're understanding that, set your expectations accordingly. Make sure that you're communicating these things, and your attorney will communicate or should communicate these things to you as well. So the next thing is, and this one is a little more nuanced on that one, strategic delays. Your attorney knows the system better than you do most of the time. I'm not saying there aren't some exceptions to that. Some people love to represent themselves. Attorney, client, people, don't understand that responding quickly to something isn't always the best course of action. And the reason why is because patience usually wins. So sometimes delays can be strategic, giving your attorney more time to gather evidence or negotiate better terms. So don't think that just because the attorney's not doing something that there's not a purpose. Sometimes, in full disclosure and full disclaimer, sometimes the attorney drops the ball. And that happens. We're people, we're humans, mistakes happen. It shouldn't, but we do. how they fix it should be the next part of the equation. Thank you, Metaverse. I will get to your question in just a minute. So if you want to stick around, I'll get to you. So sometimes delaying can be strategic as opposed to because they made a mistake, okay? So regularly check in once a week, once every other week, once a month. But remember, and they should communicate this to you, don't press for faster results because then that can cause additional problems later, okay? So trust that in certain circumstances, it makes sense to go fast. In other circumstances, it makes sense to go slow. And it depends on your unique situation and what your needs are as well as your case needs, because sometimes those aren't necessarily the same. So the more you understand the process, the happier you're going to be and the better the outcome. So the next thing is the truth about winning in court. So again, the media has a terrible portrayal of winning, okay? If you go to court and it takes you 3+ years to get there and you win, great, wonderful. But what if you could have a smaller amount quicker, right? A guaranteed smaller amount. Because we'll talk about collections at a different day, collecting on your judgment. It's not automatic, in case you were ever wondering on that. Just because you win in court doesn't mean the battle is over. The battle just means that the war, I should say, in that respect, the war is not over. There is still a battle after you get your judgment, okay? And we'll talk about that. But so if I can prove to you mathematically that 9 times out of 10, a reasonable settlement today is worth taking over a possible settlement, a possible win in 3 years, right? It's called the time value of money, meaning money has more value today than it does in next week, next year, 3 years, right? Whatever it is. So keep that in mind. If a good attorney is going to look at that time value of money and say, okay, yeah, your damages are this, and if we take this now, you are going to be fully compensated for it. If the other side is jerking you around and giving you junk, giving you no satisfactory damages whatsoever, then it makes sense to continue to trial, right? But if they're giving you a reasonable settlement based on your actual damages, then more times than not, it makes sense to take the settlement. Do not get trapped into the thinking that you want a moral victory in court. And the reason why is because that shows you're emotionally involved in it. And the jury and or the judge, depending on what type of case you have, is not going to be emotionally involved in the case. So you get attached with an outcome and you get before a jury and the jury is not friendly to you, no matter how good of a case you have, you could potentially lose. Because you're having 6 or 12, depending on your jurisdiction, people decide what's a fact, what's true, right? So you're putting your fate in somebody else's hands, which in some instances that makes sense because your case warrants it and the other side isn't playing ball. Sometimes we need to have people that are outside the dispute make a decision for us, and that's the purpose of the jury. But if you can win without that, and again, I can show you mathematically that it's true that you can do that, then why go through the bother of a trial? Why go through the headache, the pain, the anxiety, all of those things that go with the trial for a maybe when you can have a definite? Again, depends on the circumstances. Next, and that goes to the cost versus benefit. How much are you spending in legal fees? How much could you potentially get back? There reaches a certain point that it says, okay, if I settle for $50,000 and my legal fees are $40,000, and I'm not saying that's true, I'm just giving you numbers here, please don't freak out on me, then it makes sense to settle for $50,000 rather than spending $40,000, right? Because you can spend less and get more in those instances. Now, every case is different. So your attorney's going to walk through this with you, or they should, depending on the damages that you have. So talk to your attorney about this. Give them what your numbers are. What's a reasonable settlement based on your damages if you're a plaintiff? Defense, what is your total exposure regarding having to pay legal fees, right? All of those things should be discussed with your attorney on a regular basis at each stage, after written discovery, after oral discovery, okay, depositions, okay? All of those things should be discussed at that point. Evaluate their cost, value, benefit. So that is winning in court, could be a settlement sooner than later, okay? Next, trusting your attorney's strategy, okay? This can't be overstated that your attorney is there to guide you in this journey. They've been doing it. Even a law student fresh out of law school has more insight and knowledge into the law and practicing as an attorney than you do, unless you are one, okay? And even if they've never tried a case in their entire life, even if they've never done written discovery in their entire life or taken an oral deposition, they know more about the law and what's plausible, what's possible than you do. And if they don't know, they have a duty to find out, okay? So if that's true, then part of this is you need to value that time that they took in law school. You need to value their expertise because they've been involved with the court cases. They've been involved with the matters to do that. Most attorneys have had internships or practical experience before they become an attorney. Most, not all. So make sure that you're utilizing their experience. And if an attorney doesn't know what something is, and they'll reach out to other attorneys to ask questions that have been in similar positions. They're not going this completely 100% alone, even if they're a solo. So if there's something they haven't experienced before, they will find out the answer. So use that, value that, make sure that you're listening to them. If you're going against them, if you're trying to try your own case, if you're trying to do facts behind their back, or you're not doing the stuff that's necessary, or you're doing too much, sometimes cases don't take as much as what the plaintiff wants. Or defense. Defense might be obstructing the case and causing undue delay in the matter that is not reasonable, right? So make sure that you're taking your attorney's experience into account when you're making decisions. Google is not your friend. We're going to talk about that in tomorrow's video. We're going to talk about Google versus a law degree. And we're going to go over why you should be cautious about everything you read on Google. And this is not me trying to, you're not hiring me. There's no attorney here. I'm not selling you on anything. I'm not telling you that you can't believe anything that Google says, but I'm going to go over why that should not be your go-to place in the respect of don't believe Google over an attorney. Don't, generally speaking. There are exceptions to that. We'll talk about that. Okay, consistent communication. If you're unsure of what's happening in your case, reach out to your attorney. Communicate with them. Make sure that they understand that you have concerns or that you're unsure of their strategy. If you don't know what's going on, talk to them. Be reasonable, but schedule regular strategy sessions, opportunities to ask questions where you're at in the case. Don't make the mistake of being overly communicative, right? Where you're driving the attorney nuts because we have, 15, 20, 30, 50, 100 cases, and you're taking up a disproportionate amount of time because we have other cases we have to work on. You're not our only client. That's just an acknowledgement of truth, fact, okay? It's not that we don't want to help you. It's that we also have to help everyone else that are our clients. So check in with them regularly. If it's once a month, once every other 2 weeks, depending on the case, it could be months because things move slow. Be patient, okay? And make sure you're compiling a list of all of your questions so that you don't forget anything, right? And again, we're not mind readers. I wish we were, truly. That would make our jobs amazingly easier. So if we don't know that something concerns you, we can't solve it, okay? We can't solve a problem we don't know exists. So please communicate that, but take a list, make a list of all of your questions, keep a list. Something that's concerning, I tell my clients, if something's bothering you and keeping you up at night, I want to know about it, about the case. That's my disclosure. Okay, so next, the challenge of changing attorneys mid-case. Generally speaking, unless your attorney has dropped the ball significantly, okay, and we're talking like really bad, it's most of the time better to dance with the one that brought you, okay? Because switching attorneys can lead to delays as the new attorney has to get up to speed and potentially weakening your case. The new lawyer will also bill you for time they have to spend learning about your case and potentially costing you higher legal fees. Now, this doesn't apply in every case, so keep that in mind. There are some instances which, if you're on contingency, that the legal fees, that's a different story. Okay. But where this gets a little more dicey is if your attorney no longer wants to represent you, but you still want them to represent you. And that usually happens when an attorney-client relationship breaks down, when there's a disconnect between the attorney and the client such that the attorney cannot ethically represent you. And in those instances, then they can ask to be removed as counsel. And it really depends on the facts of that case. So keep in mind, so if it's a crappy attorney, you can always fire the crappy attorney, but attorneys can't always get rid of clients easily. So the reason why I bring that up is because the better client you are, the less likely that stuff will happen, okay? So this is something that is unfortunate. It happens. That's why I'm talking about these things, to address them so that you can have better successful outcomes without having to change attorneys, okay? If you do change an attorney mid-case, it is more likely than not going to cost you more. That's just a truth. So be cautious and be patient with your attorney if you can. If the attorney is screwing up massively, I do use that term because we're human, we make mistakes. Be patient with us. We are not robots that are just processing paperwork. We're looking critically at issues. We're deciding strategies. We're thinking about the hard issues. We're doing all of these things to help move your case forward. And that doesn't mean that we have everything locked into our brains or into the systems that we have. And so occasionally mistakes happen. Understand that we will do our best to correct the mistakes, but don't judge us and don't yell at us for being human. Just like you make mistakes in your life, please don't judge us for making mistakes in ours. Now, so if you are in that decision-making process of trying to decide whether you should keep your attorney or not, try to have a come to Jesus moment would be the best way of characterizing it, but a mediation or a very candid conversation about them and explain to them your feelings, your thoughts, your concerns, and discuss it and ask them, is this working for them? Is there something that you can do as a client that is causing a breakdown in that relationship? It goes both ways, right? Attorneys can be difficult and clients can be difficult. They both can, or either or both, right? So it's not an either or situation. You both could just not be working well together. It could just be that what you thought was going to be a great attorney-client relationship turned into not so one. And it may have nothing to do with their quality of representation. It might just be a personality conflict. And acknowledging that and saying, look, I understand, let's part ways and do our own thing, and you do your thing and I'll do my thing. And yes, it's a little more money, but I feel like I'll have a better outcome with somebody else. Okay. But be careful. And here's one of the things about changing. This one's really important. Okay. I need you to listen. I need you to put your ears on. A lot of attorneys won't take over a case for another attorney. They want to start because the assumption, and I'm not saying this is accurate, I'm saying the assumption, the unfortunate truth is this, that there's something wrong with you as a client, or there's something wrong with the case. Now, the attorney that you're leaving can't tell them that. There's no way they can say, oh, this is a bad client, because attorney-client relationship exists regardless of what happens there. But some attorneys will not take your case simply because of those two things. Either there's something wrong with the relationship or there's something wrong with the case. And so you will have a harder time finding a new attorney to represent you. And again, it will cost you more. So you need to weigh that benefit, the mistakes that your previous attorney has made, the relationship that you have with them, with the cost that it's going to incur to change attorneys. Look at those, evaluate that. If it makes sense and you're willing to take those risks, then by all means, and you're going to have a better, more successful outcome with a different attorney, then make the change. Okay, but don't just make it because they didn't respond to your messages for a week, right? Because they may not have an answer. I don't know. I'm just saying. Remember, the justice system moves slowly. Be patient. We'll get you a long, long, long way. All right, next. That kind of segues quite beautifully into this one. Legal outcomes, very, very slow. Courts are backlogged. There are procedural requirements, as I talked about previously. From the moment you file a summons and complaint to the time that the other party has to answer is a minimum of 30 days in California. Every state, every court has their own different things, so to keep that in mind. Your mileage may vary on this, right? So procedural requirements, negotiating periods, all of these things contribute to delays. It might be a simple, easy thing, but it might not be. And it might turn into something because the other side is not willing to negotiate on something, and you can't force them to negotiate on it. You can try, but at the end of the day, if they say no, there's not much you can do about that. You can't force them to negotiate. You can bring them to the table. You can ask to come to the table. You can talk about the behavior that brought you to where you are, but you can't force them, right? That's the whole point of going to court. There's a dispute. The other thing you have to understand is this. Courts don't want you there, okay? I'm sorry, this is true. They want you to solve your own problems without the involvement of court. So they make it harder on you. They make it more difficult to get to court by putting all of these procedural roadblocks in there, making it more costly. Why? Because they're already backlogged, because they already have these crazy procedural requirements in there. So keep in mind, if you can resolve your conflict out of court, I'm not saying it's always better. I'm saying that it should be a real consideration. Taking your matter to court should be something you discuss with your attorney and make sure you understand the consequences of that and the time period surrounding it. Remember, I said it could be anywhere between a year all the way up to 5 years, depending on where you're at, okay, at least California-wise. So keep these thoughts in mind. Next, embracing the process. Patience. Oh my gosh, this is probably the best tip I can tell you. The more patience you have, 99% of the time, the better the outcome will be. If you are patient with the process and patient with the attorney, you will see significantly more success than if you are impatient and try to push and make it happen faster than it needs to. Okay? I can tell you this with almost 100% certainty. The most patient party usually wins, whether it be in before trial or at trial. The party that is willing to go the distance and is willing to be patient to get the outcome that they want is usually the winner. Now, unfortunately, here's the next part of that truth. Patience can equal money, unfortunately, depending on your case. I can't say that with absolute certainty on every case, but I can say if you're paying legal fees, patience equals money. Would you rather, in a defense case, would you rather settle for a lot of money in the beginning and a little bit at the end, or vice versa, right? So patience gets you everywhere, but your legal fees will depend on that too. So keep those types of thoughts in mind as you're going through this process, that your situation, patience will get you further than being impatient. And if you're being impatient, that's one of the reasons why attorneys won't want to work with you. Okay, because there's so much that we can't control. Remember, go back to slide number 1. Okay, There's so much that we can't control that you being impatient doesn't make the situation better. It just doesn't. There's no way to make it better if you're not patient, right? We can't navigate it faster than what the situation will allow us to do. If you struggle with this sort of thing, seek outside counseling, BFFs, people that can help you, like calm you down, deal with your patients, right? If you need a therapist, see a therapist. It's a lot cheaper than an attorney. I'll be honest with you. That's a true statement, right? Don't yell at your attorney for things that your attorney has no control over. That's not helpful. That's not useful. That does not get you any further. And it costs you money. If you want to talk to somebody that's going to listen to you and doesn't involve that you need to vent your frustrations over the process, vent it to a licensed therapist that can help you actually deal with it, rather than the attorney that is doing his or her best to navigate the situation, that we can't force it any faster than we can. So learning these coping techniques, mechanisms to get you the most favorable outcome that you're looking for. So that, my friends, is it. Those are the things that you can do to have a better relationship with your attorney so that you can have a better outcome, right? Because it's not just about trial or the settlement. The journey has to be acknowledged. You have to look at the journey and say, how can I get from point A to point B in the best way possible? So that means having that positive, amazing relationship with your attorney in a way that makes you feel good and doesn't leave you frustrated, right? There's nothing worse than having a problem, hiring someone to fix that problem, and then being more frustrated with the person that's hired to fix the problem than the problem itself. So as you are more patient and you're getting the help that you need, whether it be through therapy or having someone you can vent to, you are going to have a more successful outcome. And if you do struggle with things that require therapy, then please get help. Get the help that you need to have a best successful outcome, because again, the journey matters. Well, that's it. If you've gotten value out of this video, don't forget to hit subscribe and like, and we'll talk to you later. Bye.